Hello aspirants, welcome to the Shankar's Summary, an initiative by the Shankar IAS Academy to present to you the important current affairs which were discussed from the year of 2024 to 25 subject wise. So this video is for the subject polity. So through the video we would be discussing important current affairs which were discussed frequently for the year and along with practice questions. So I hope this video helps for you to boost your UPSC Prelims practice as well as stands as a quick revision. So let's get into the topics to be discussed. So we have chosen 25 important topics from the current affairs and we would be discussing each of the basics and constitution provisions of these topics and we would be seeing practice question for it. So we have already uploaded 3 videos for the subject history, geography and science and technology, and this would be the 4th video for the polity. So put in the comment section if you are happy with this initiative, and at the same time put in the comment section on which other subjects we need to be covering on. So now without any delay, let's get into the topics discussion one by one. Now let's look into the first topic, that is the Pravasi Bharatiya Divas. So it is a day to celebrate on January 9 to honor the contributions of the Indian diaspora to India's development, and that's why it was in the news. And why the date specifically? That is to commemorate the return of Mahatma Gandhi from South Africa to India, which happened on January 9th of 1915. So to brush up, we all know our Indian diaspora consists of NRIs, that is the non-residents of India, the OCIs, that is the overseas citizens of India, and also PIO, persons of Indian origin. So in light of this article, let us see few constitutional provisions on why it is important. First, it comes under the Ministry of External Affairs, and there are 2 constitutional provisions to be focusing on. First, this article mainly comes under Article 5 to 11 of our Indian Constitution, where it deals with citizenship. So this is one of the most frequently asked questions in our UPSC prelims. So under the articles, Article 9 can be taken into account on this for this news, as it talks about no dual citizenship in India. So here the OCI holders cannot have dual citizenship in India. And next is about the Citizenship Act of 1955, where it describes the OCI's card holder rights, and also we should know the basics modes of acquiring Indian citizenship, that is through 5 modes, that is through birth, through descent, through registration, through naturalization, and also through integrating our Indian territory. And also we should know modes of loss of citizenship in India, that is through renunciation, termination and deprivation. So after knowing about citizenship, we should also know about the merging of the scheme of PIO, that is the persons of Indian origin, scheme was merged with the OCI in 2015 in itself. So the Indian diaspora consists of the NRIs and also the OCIs, where it includes PIO also. And next, the Overseas Indian Affairs Division originally were now merged with MEA, that is Ministry of External Affairs. So everything comes under Ministry of External Affairs. So in light of this article, brush up the basics and also know about the Constitutional Amendment Act, which was made in 2019, and its constitutional implications for both prelims as well as for mains understanding. So in light of this article, let's see a prelims practice question. It is celebrated annually to mark the return of Gandhi from South Africa. The OCI have the right to vote in India. The Pravasi Bharatiya Samman is awarded by Ministry of External Affairs. So which of these statements are correct? So here statement 1 is incorrect, statement 2 is incorrect, and statement 3 is correct. It is celebrated not annually but biennially, that is every 2 years this is the Pravasi Bharatiya Divas is celebrated. So this was since 2015. So before 2015 it was celebrated annually, but after 2015 it is celebrated biennially. And next statement is wrong. Here the OCI doesn't have the right to vote. OCI holders have no voting right. It is only the NRIs who would be having the right to vote. That too, they have to be physically present in India along with the passport of theirs. And statement 3 is correct. The award is given by the Ministry of External Affairs. So I hope the article is clear. Let's move on to the next topic. Next topic is the Sankari Prasad Singh Dio versus the Union of India 1951 case. So here why it was in the news, because since the year of 75th year of our Indian constitution, remembering landmark judgments, so this was also one of the landmark judgments, that is Sankari Prasad Singh Dio versus Union of India and also versus the state of Bihar, as it is one of the landmark judgments, as they upheld the first constitutional amendment that was abolished the zamindari system. So let's see the constitution provisions included on this article and why it is important. So first, the article 31 talks about the right to property before. So originally it was part of the fundamental rights and it guaranteed protection from arbitrary deprivation of property by the state. So here they included no person shall be deprived of property except by the authority of law or by the law, and here the state can acquire property only for public purpose and with compensation. So this was originally under article 31, that is right to property, and then came the first amendment. Here the first amendment was this case where they added articles 31A and 31B, where it protected the land reform laws through 9th schedule. So here through the first amendment of this case, they brought in 31A and 31B in the article 31, where they brought the introduction of the 9th schedule. So here through the 9th schedule, they protected the land reforms laws. So this is the information about the first amendment which was made, that is through this case. And then further in 1978, the whole article 31 was repealed, that is they were removed as right to property from the fundamental rights. So since 1978, the right to property is now a legal right and not a fundamental right, and it comes under article 300A. So here the article 300A talks about no person shall be deprived of his property which can be saved by the authority of law. So these are the information regarding this judgment. So let's see a prelims practice question. First, in reference to Shankar Prasad versus Union of India, consider the following statements. It was the first case to test Parliament's power under Article 368. The court held the constitutional amendments are not law. Under Article 13 Clause 2, the court struck down the first Constitutional Amendment Act 1951. So here the first statement is right. It is the first case testing amendment power under Article 368. So here originally Article 368 was how Parliament have the right to bring in constitutional amendments on any constitutional provision. So this was come under Article 368. But along with this landmark judgment, there was also another landmark judgment, that is in year 1973, that is the Kesavananda Bharati case, where they brought in the understanding of the basic structure, and the basic structure cannot be amended even under constitutional amendments. So here through that case, we all know that no fundamental rights can be amended as it is part of the basic structure, and this was given by the 1973 Kesavananda Bharati case. So after 1973 only, the 44th amendment came into act, where they repealed the Article 31 and they brought the right to property as a legal right and not a fundamental right. So here you can know how statement 3 is incorrect. The court upheld, they did not strike down the first amendment, and statement 2 is correct. Here the amendments are not taken as law. So and it comes under the Article 12, so it cannot be struck down for violating fundamental rights. So here they did not struck down, the court upheld the first amendment. So this is the constitutional history of this article, and it is one of the most important article to be taken in account. So revise the basics all again. Now moving to the next topics, that is about the constitutional bodies. So here throughout the year we have seen different newses regarding the Panchayati Raj movements, regarding Attorney General involvement, and also how in this these 2 years we have in this years we have seen the Chief Justice of India to be appointed, and also the Chief Election Commissioner Gyanesh Kumar would be taking in over about the election commission. So in light of this article, it is important to brush up about the constitutional bodies. So here is a prelims practice question. The column A consists of the bodies, which is Chief Election Commissioner, the Election Commissioner, Panchayati Raj, Attorney General of India, and Chief Justice of India. And the column B consists of what all of the bodies they include. So which of the pairs are right? 2 pairs, 3 pairs, 4 pairs, and all pairs. The answer is only 3 pairs are right. So again you have to brush up the concepts. Statement 1 is right. The Chief Election Commissioner, it comes under the Article 324 and they are constitutional body. So it is a constitutional provision for the Election Commission. And the next article, next body, that is the Election Commission, they are not under statutory body. So ECI is also a constitutional body under the Article 324. Here Panchayati Raj, it is part of the Act of Parliament, but it is not created by an Act of Parliament, and let's see why and why this option is wrong. Here statement 3 is incorrect because the Panchayati Raj system was created by the Constitution under Article under 243 to 243. So through the 73rd Constitutional Amendment Act 1992. So here it is not created by an Act of Parliament but by a constitutional amendment. So the inclusion was made through a constitutional amendment and they are not created by an Act of Parliament, but it doesn't mean they don't come, but it means that they come under the constitutional bodies ultimately. They are formed as a constitutional amendment and not created by an Act of Parliament. So this is how you can get confusing statements regarding the understanding of a act and the body or the articles associated with it. So be careful on understanding the concepts. And its statement 4 is right. AGI is under Article 76. The office is part of the Union Executive. And here statement 5 is incorrect as CGI is not a statutory body again. The CGI, that is Chief Justice of India, comes under Article 124 and the office is created directly by the Constitution. So it is important for us to brush up all of these articles and also look into the composition of the members of these bodies as well as the tenures for each of the members involved. Now let us move on to the next topic, that is our fourth question, where it deals with different articles. As we throughout the year we have seen a lot of news regarding these articles, that is about free speech index, about Article 356, Article 371, article on pending bills and article on 101. So in light of this article, let us see a prelims question and basics about it. So here this is the question and all of these articles, check which pairs are correct. So here option A is right, that is Article 1 here talks about the governor's assent to bill, where Article 200 talks about governors can assent, withhold or reserve a bill for the president. And next article 101 deals about the vacation of seats in parliament where it for example double membership. Next article 371 deals about special provisions for states like Maharashtra, Gujarat and Nagaland, etc. The next article 356 talks about the imposition of president's rule upon failure of constitutional machinery. And the article 19 clause 1 clause A talks about the fundamental right, that is freedom of speech and expression. As we have seen news that recently India was ranked 24th out of 33 countries in free speech index. So this is how you have to gather the importance of news and how important these articles have the potentiality to come in the exams also. So brush up the basics for these articles. Now looking into the next topic, that is the anti-conversion law. So why it was in the news? Because in 2025 the state Rajasthan have enacted the prohibition of unlawful conversion of religion bill. So here this legislation introduces stringent procedures for religious conversions, including mandatory prior approval from the district authorities. So let us see the constitutional provisions included. So we'll see the constitutional provisions through the prelims practice question. Here I have given a case study. Let us read the case study here. Here a person called Rahul organizes a public event in Madhya Pradesh where he distributes food and speaks about his religion. Some voluntary express interest in converting, and Rahul facilitates this without prior intimation to the district magistrate. So here a complaint is filed under the state's anti-conversion law. So here in context of this scenario, let us understand about the bill. So here we all know Article 25-28 talks about the right to freedom. So here article statement 1 is right as it allows propagation but not conversion through force or allurement. Next, there needs to be a prior district management's notice and anti-conversion law. And next, material aid like food can be treated as allurement under such laws. And the Supreme Court held this case to uphold the constitutional validity of anti-conversions law. So all of these statements are right, and these are the constitutional provisions to note down on this article. Now the next topic is about the Places of Worship Act 1991. So why it was in the news? The Supreme Court began hearing petitions regarding the challenging of the Places Worship Act of 1991. So this act, it preserves the religious status character of places as of August 15, 1947. So till the date of 1947, any religious characteristics or any religious infrastructures should be maintained and preserved of their religious characters. So this is the Places of Worship Act of 1991. So now why it is in the news? Because shrines like Gyanvapi and Sahi Idka now have major implications and the challenges given, as there are talks that it hurts the secularism, communal harmony and constitutional interpretation of India. So in light of this article, let us see the important constitutional provisions to be taken into account. So first, what is Places of Worship Act of 1991 under special provisions? It freezes the religious character of all places of worship as on 15th August 1947. So it bars, that means it constrains the conversion or litigation to change the religious identity of any place, exception the Ram Janmabhoomi and the Babri Masjid dispute. As this dispute was way early before, it was way early during the year of 1940s to 50s and whole going on. So only this place was accepted and other religious places were taken into account. Now you have understood about the Places of Worship Act. Now we should see what the act also includes, that is Ancient Monuments and Archaeological Sites and Remains Act of 1958. So here the places covered under this act are exempt from 1991 Act, and it protects and preserves monuments of national importance. Now looking into other provisionals, we need to know about Article 25-28. They come under right to freedom of religion. Next, Article 25 ensures freedom to freely profess, practice, propagate religion. Then Article 26, it grants religious denominations the right to manage their own affairs in matter of religion. And Article 14 guarantees equality and protection. Article 15 prohibits discrimination on grounds of religion, race, caste, sex and place of birth. And Article 32, it provides the right to constitutional remedies for the enforcement of fundamental rights. So here again, through this article, we need to know the brushing up of these basic articles. Now this article has a potential to be both prelims and mains, because there has been challenges given as how it distracts the basic structure doctrine, as it limits the judicial review and affecting secularism was one of the counterpart argument. Now in light of this article, let us see a prelims practice question. So with reference to the act, consider the following statement. So here all of these statements are right. The act prohibits the conversion of all religious character existed on 1947 except the Ram Janmabhoomi and Babri Masjid site, or sometimes they can ask only this statement without an exception for Babri Masjid and Janmabhoomi sentence. They can just ask about the act prohibits the conversion of all religious character of places of worship. So when it comes, that statement is wrong. Now the next statement is also right. The act prevents courts from hearing cases seeking to alter the religious character of any place. That is correct. And next, the act has been challenged in Supreme Court on the grounds that it violates Article 25 and Article 14. That is correct. So here the act is currently under legal challenge in Supreme Court. Now the next topic is about the minority status. Now why it is in the news? Because the Aligarh Muslim University wanted to claim their minority status, and that's why it was in the news. So what's the issue? The Aligarh Muslim University wanted to have minority status under being as an established educational institute. So for any educational institute to come under Article 30 clause 1, to attain minority status, they need to be established and they have to be administered by a minority community, which can be religious or linguistic in nature. Now looking into the historical background of the issue, the AMU was earlier known as Mohammedan Anglo-Oriental College, and it was founded by a Muslim community. But later it was formally under the university by the British government under Aligarh Muslim University Act. So in 1967, through the case of Aziz Basha, the Supreme Court ruled that AMU is created by Parliament and not by Muslims, and it cannot claim Article 30 clause 1 rights. But in 1981, the Parliament amended that AMU can claim, but again in 2006, the High Court have struck down the amendment and citing that 1967 rule is the precedent. So so now in recent year, again the AMU want to claim their minority status. So in light of this articles, it's very important to go through the basics. So here we all know Article 29 to 30 come for the protection of interest of minorities and also for the rights of minorities to establish and administer educational institutions. So you can pause the video and take a screenshot. Here Article 29 and Article 30 have been given their introduction. Now we should also see about Article 15 clause 5, where it talks about special provisions for weaker sections for their advancement, and this comes under 93rd Constitutional Amendment Act of 2005. So here state can make special provisions, can be socially and educationally backward classes for SC and STs in educational institutions. So here in this article, minority institutions are specifically exempted, that they are not in this clause. Now what is this state? So if AMU is declared minority, they can reserve seats, they have like 50% or more, and they don't need to implement whatever quotas comes under Article 50. But AMU is not into minority status, they have to function as a secular public university rather than being a religious based university, and they have to abide to all state policies. So these are the constitutional provisions for this article, and it is one of the most important basics for us to know. So a general idea about minorities, they can be divided into religious and both linguistic. So from Article 29 to 30, and 29 30 about religious, whereas 350A and 350B are mostly for linguistics. And also in through law, minorities comes under National Commission for Minorities Act 1992. So here there are 6 minorities according to the act, that is, we all know Muslims, Christians, Parsis, Sikhs, Buddhists, and Jains, who are recently joined in 2014. So Article 366, Anglo-Indians are in minorities. In through Article 331 and 333, the Anglo-Indians were given special status of special provisions, and through the 104th Amendment Act, they were striked. So these are the basics when it comes to minorities. So give a revision on it. Now looking into prelims practice question. In India, if a religious sect or community is given the status of a national minority, what special advantages they are entitled to? First, it can establish and administer exclusive educational institutions and it is right under Article 30 Clause 1. Now, the President of India automatically nominates a representative to community to Lok Sabha. I think it's incorrect because here the President can nominate 2 members from Anglo-Indian community to Lok Sabha as per the Article 331, but this was abolished by 104th Constitutional Amendment Act of 2020. Now, the third statement, it can derive benefits from the Prime Minister's 15-point program, and this article and statement is right here. The PM's 15-point program for welfare of minorities, which was launched in 2006, they target the nationally declared minority communities. So here only option C is right, 1 and 3 is right. Now looking into next topic, the Water Act. So here new rules have been notified for the Water Act. So let us see the basics. Here it comes under the Water Prevention Control of Pollution Amendment Act of 2024 to modernize India's water pollution to control framework. So they come under Article 252. The original Water Act of 1974 was enacted under Article 252, allowing the Parliament to legislate for 2 or more states. Okay, then it comes under Article 21 to ensure the right to life, which have also included the right to clean and have a healthy environment. Article 48A directs the state to protect and improve the environment and safeguard the forest and wildlife. So here why we are taking this news as an important news, because it comes under the control of the state pollution control boards. So here they are one of the important statutory bodies and they are not constitutional regulatory bodies. They are statutory bodies and they are created under a specific act of the Parliament. So for years we have been having a focus in polity related to different bodies, that is statutory, that is constitutional, regulatory. So such news are very important for us to know about the bodies in constitutional as well as statutory bodies of Indian Constitution. And they also come under Article 51 G, A, Clause G. Here it imposes a fundamental duty on every citizen to protect and improve the natural environment, including forests, lakes, rivers, and wildlife. So now looking into a prelims practice question. Here this was question for the year of 2019, I guess. So here they have given certain organizations or bodies and they have asked what are the constitutional bodies. So here we know the National Human Rights Commission, they are a statutory body. And the National Consumer Dispute Redressal, they are also a statutory body. They come under Consumer Rights Act. So every statutory body is created by law, so they come under an act. So through such questions we can expect about statutory bodies and as well as about constitutional bodies. Now looking into the next topic, it is about the Oilfields Regulation and Development Amendment Bill 2024. So why it is on the news, because it was passed in the Lok Sabha after earlier approval of Rajya Sabha. So here the legislation, it marks a significant change from the colonial era of having a royalty and now to even more modernized way of getting approval for oil fields. So they come under the Oil Fields Regulation and Development Act of 1948. That is to modernize India's oil and gas sector and attract greater investment. So this is why it was in the news. Now let us look into the constitutional provisions on why this article is important, because the oil fields regulation is a union subject and not a state subject. So here the union subject comes under the 7th schedule of our Indian Constitution. So we all know there are different schedules being created in a constitution and have a revise on it. So here the 7th Constitution distributes the legislative powers between the union and the state under Article 246. So here they contain 3 lists, that is the union, state, so and the concurrent list that define subjects on which laws can be made. So here the concurrent list, those subjects can be administered by both union as well as state. So if there is a conflict between union and state law on the concurrent list subject, the union law prevails under Article 254. So for oil fields, it comes under petroleum and mineral resources and they fall under union list through entry 53. So here the 7th schedule was created at the time of adoption of our Constitution of India under the Government of India Act, and it was on 26th of January 1950. So the nodal ministry is Ministry of Petroleum and Natural Gas. So these are the basics you need to know about our constitutional provisions on according to this article, and also have your focus on knowing different schedules of our constitution. Now here we can see, so this is one of a prelims question, I think it was in 2019 I guess. So this about scheduled areas, they come under schedule 5th. So you can expect questions, or you need to know basics on different schedules of our constitution. Now looking into the next topic, one of the most spoken topic would be one nation, one election. So here under the Ministry of Law and Justice, our India has been having a focus on creating one nation and one election simultaneously. So here it is known as simultaneous elections, to aligning the election cycles of Lok Sabha and state assemblies. So here you need to know basics about Lok Sabha, their tenure, their way of conducting elections, and also for the state assembly. So all of these basics you need to know, and especially we need to focus on the basics of elections. So here looking into constitutional provisions, the article 324 grants the election commission to power to manage elections, okay. And article 32, 325, 326, 327, they focus on inclusive and universal adult suffrage. And article 328, 329, they deal with state level elections and ensure independence of elections process by limiting judicial interference. So here article 240, 324 to 329 exclusively discusses about elections. Now looking into other constitution provisions related to this article is because if you are going to continue or simultaneous elections, you have to look into the tenures of Lok Sabha and the other state assemblies. So here take a screenshot, the article 3083 clause 2, look into the term of Lok Sabha, then article 177 on the state tenures, 85 to 74 again to looking into the power to dissolve and summon the parliament and state assemblies. Then as I told about article 324 on the election commission, then article 356 on president rule to align the election cycles, and again it comes in the 7th schedule as elections fall under the state list but conduct under union control. And article 368 amendment process, there are so much of basics to be covered up on this topic in itself, on election processes, electoral reforms, on how election are be conducted, on the model code of conduct, and how amendments are made. So here you need to brush up a lot of basics, and also about Lok Sabha, Rajya Sabha, and the parliament, and also how different amendments were made and how different amendments can be done. So here through this article, the important amendment is 42nd and 44th, as during the national emergency the tenures were increased and then it was reversed back. So these amendments are very important for you guys to note. Take a screenshot and revise. Here other information you can take in is through 61st amendment, the voting age was reduced from 21 to 18. Then article 329 discusses about the election petitions, and laws governing elections are a Representation of People Act of 1950, Representation of People Act 1951, and the amendments added. So this topic is one of the reminder for us to have our basics very strong on elections and the Election Commission of India and their constitutional provisions and the basics of the polity on it. So looking into the prelims practice question, here you can see I think this question was from 2016. They spoke about the what is the 44th amendment. So here they have taken examples for 44th amendment, they have taken examples from 99th amendment. So this is how repeatedly we can expect a question from UPSC. Now looking about the next topic is about the manual scavengers. So here why it is on the news, because the National Human Rights Commission India have organized open house discussion on dignity, liberty of the individuals, that is the rights of the manual scavengers. So here it comes under the National Human Rights Commission. So looking into the constitutional provisions, it comes under Article 17 on the abolition of untouchability, and seen as a violation of human rights, as it titles with the social evils which is tied to the caste system. Next is looking into the prohibition of employment as manual scavengers and the Rehabilitation Act of 2018. So they work on prohibiting on the employment, they mandate rehabilitation, bring in penalties and eradicate manual scavenging. Focus. Article 46 promote on the welfare of the scheduled caste, scheduled tribes and other backward classes. So here the state is responsible for promoting the welfare of these communities. And next act included should be the National Commission for Safai Karamcharis Act of 1993, and they come under statutory body and they are created under a statutory body. So here they come under a act. Next is the National Commission for the Scheduled Caste is a constitutional body and focusing on the protection of the rights of scheduled caste. The next is constitution having the scheduled caste order 1950 where it defines the scheduled caste, and the SC/ST Prevention of Atrocities Act of 1989 are enacted to prevent atrocities and discrimination against scheduled castes and scheduled tribes. Now look into this prelims practice question. Here it was a direct question by UPSC. Here Rashtriya Garima Abhiyan is a national campaign to eradicate the practice of manual scavenging and rehabilitate the manual scavengers. Moving on to the next topic, the PESA Act. So here why it is on the news, because it has boosted the forest conservation in India. Abbreviated as the Panchayat Extension to Scheduled Areas Act, has objective to empower the scheduled tribes of that particular area. So looking into the introduction, they were enacted on December 1996 as the act is part of the part 9 of the constitution, that is the Panchayati Raj. So this act extends to the 5th schedule areas. So here the 5th schedule comes under article 244 clause 1 stating the 5th schedule, the provisions of 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura and Mizoram. So exempting these 4 states, the 5th schedule compromises other states. So check the other states. And the article 244 clause 2 applies for the 6th schedule, which includes these states. So the objective is to introduce self-governance in tribal areas, and they are based on Buria committee recommendations. So look into various committees for polity references. And looking into other legal frameworks, they come under Governor and Tribes Advisory Council, who are responsible for tribal welfare, and they mandated states with scheduled areas to amend their Panchayati Raj Acts to align with PESA in within a year of 1 year, that is 1997. So here PESA gives Gram Sabha's power in tribal areas, so it is in the concurrent list and it comes under both the administration of state as well as the center. Now looking into the prelims practice question, the PESA extends to this part of constitution to both 5th and 6th schedule areas. No, only 5th schedule. Next, the Gram Sabha have the power to manage minor water bodies and regulate the sale of intoxicants, and that is right. They can regulate sale of liquor and minor water bodies. Next, the state government were required to amend their Panchayati Raj Acts to align with PESA by 97, and that is also right. So here the PESA mandates the creation of tribal advisory councils at district level. No, the tribal advisory councils are created under the 5th schedule and not PESA. So only 2 and 3 are right. Now looking into the next topic, emergency provisions in India. So why it was in the news, as a Lok Sabha Speaker Om Birla reads a resolution on emergency. So looking into the emergency provisions in our Indian constitution, they are part of part 18, where they come under the articles 352 to 360. So here historically, inspired by the Government of India Act of 1935, section 4593, then Weimar Constitution of Germany, and Governor General who had wide powers in provinces historically. Now looking into few constitutional assembly debates. So here emergency was largely used by during a presidential rule in 1970s, where the article 32 was suspended. So here article 32 is known to be it is known to be the heart and soul of our constitution by B.R. Ambedkar, as the main article, the article 32 provides constitutional remedies. So check the constitutional remedies for basics. So first it was suspended, and then the final version allow the suspension under certain circumstances. So here in article 32, for for the fundamental rights, people can go to the administration of fundamental rights to the Supreme Court, and that was suspended during the emergency rule. And later on, during the national emergency, under Article 359, Article 32 can be suspended only under certain circumstances, except for the rights under Article 20 and 21. So here it was amended through the 44th Amendment, and also they included judicial review, which were restored by the 44th Amendment. So looking into the types of emergency: national emergency, Article 352; state emergency or presidential rule, Article 356; financial emergency, Article 360. Looking into key constitutional amendments: 42nd Amendment of 1976. Here they removed the judicial review during emergency and restored the judicial review in the 44th Amendment 1978. So here the emergency must be declared only on a written cabinet advice, and Articles 20 to 21 cannot be suspended even during the emergency. So these are the basics when it comes to the emergency, and have revision on the provisions. Now looking into prelims practice question: with reference to emergency provisions in Indian Constitution, consider the statement: President can declare a national emergency only upon the written recommendation of Union Cabinet. So here, yes, the statement is right. Looking into the 44th Amendment Act restored judicial review of emergency proclamations and protected certain rights from suspension. Yes. So here the question is, which of the statements are incorrect? So neither of these statements. Now looking into one of the most spoken topic, that is the BNSS, that is the Bharatiya Nagarik Suraksha Sanhita. So here why it is in the news: because India will replace the earlier criminal laws with a set of 3 new penal laws. So what is BNSS? So here it replaces the Criminal Procedure Code of 1973. So we are going to look into the important constitutional provisions. It upholds the rights of accused and victims, operates under concurrent list, states can adapt it also, ensures due process under Article 21. Then under BNSS, there is Bharatiya Sakshya Adhiniyam of 2023 was passed, and it replaces the Indian Evidence Act of 1872, as it is part of the larger criminal law reform alongside. And also under BNSS, the Bharatiya Nyaya Sanhita replaced the Indian Penal Code, that is of 1860. So these are the constitutional provisions included here: Article 20, 21A, Article 22 and Article 39A from the DPSP, and Article 246 to 7 schedule are included on this article, and important articles to be noted. So take a screenshot so you can refer, and I hope the article is clear now. Let us move on to a prelims practice question. Looking into the BNSS, consider the following statement. Here the BNSS removes the provision that mandates a magistrate prior permission for handcuffing an accused during arrest. So here, yes, the statement is right. It permits the use of handcuffs in certain cases without requiring prior judicial permission, deviating from Supreme Court guidelines. Next is, under BNSS, police custody of an accused can be authorized in parts throughout the entire period of judicial custody, even beyond 90 days. So here the statement is incorrect. The police custody can be sought in parts during the first 40 or 60 days of the 60 or 90 day remand period, and not beyond it. The next statement: the BNSS introduces plea bargaining for offences punishable with death or life imprisonment, and wrong. So here it is not allowed for offences punishable with death or life imprisonment or imprisonment over 7 years. The next, the classification of metropolitan magistrates and metropolitan areas have been removed under BNSS, and the statement is right. So here the classifications of metropolitan areas and metropolitan magistrates are removed. So here option D is only right, that is option statement 1 and 4. Now looking into next topic is the cabinet committee. So here why it is in the news: because our union government has constituted various important cabinet committees. So they have added few cabinet committees and do have a check. Now looking into cabinet committees details, it is part of the executive system where it is important for decision making for efficient governance of our country. So here looking into the composition, it comprises 3 to 8 ministers chaired by the Prime Minister or a senior cabinet minister. It allows specialized focus on political, economic and administrative matters. So these are the types of committees: permanent committees. So for example, they are given, and ad hoc committees where they are temporary, issue specific and dissolved after task completion. Now looking into their legal framework, they are governed by Transition of Business Rules 1961, and they are also based on Article 77 Clause 3 of Constitution, rules for the ministerial business. So these are the basics when it comes to the constitutional provisions for the cabinet, and do revise of their provisions. Now looking into the prelims practice question, with reference to cabinet committees in India, which of the statements are right? So here the Cabinet Committee on Political Affairs is the only committee that deals with center-state relations but excludes national security from its purview. So here the statement is right. The Cabinet Committee on Political Affairs indeed deals with center-state relations and broader political and economic issues, but not security-related matters. The Cabinet Committee on Accommodation and Cabinet Committee on Parliamentary Affairs are the only two who are not chaired by the Prime Minister, and it is correct. The third statement, cabinet committees function under the constitutional mandate of Article 77 Clause 3, and their existence is explicitly mentioned in the Constitution. No. So here, while Article 77(3) empowers the President to make rules for business transactions, cabinet committees are extra constitutional. So here, that is, they are not mentioned in the Constitution. So do not confuse with constitutional bodies as well as extra constitutional. The next statement, last, the Cabinet Commission on Security includes Minister of Finance, Defense, Home Minister, Home and External Affairs, Vice President. No, not the Vice President. So only statement 1 and 2 are right. Now moving on to the next topic, that is women in politics. So here through the 106 constitutional amendment, there has been inclusion of having 33% reservation target. So here why it is in the news also, recently it concluded general elections in UK and recorded 263 women MPs, that is 40% who have been elected to the House of Commons. Now comparing to India current status, in 1952 women held 4.41% of Lok Sabha seats. In 2024 it's not a much change, but it's just 13%, which is down from 2019. So here it is far below the proposed 33% reservation target. So check what all the articles included or inserted in the reservation bill. So here in India ranks 149th out of 193 countries in women's lower house representation. And looking into Global Gender Gap Report in 2023, India ranks 127th out of 146th country. And these are the global comparisons. So looking into Inter-Parliamentary Union for Asia includes Nepal, Bangladesh, Pakistan, Bhutan and Sri Lanka. So here in 2022 these countries were taken into account. So we can see stellar differences between the years in itself. Now looking into key constitutional provisions for the rights of women, obviously Article 14 to 16 for equality, education on Article 21A, and also voting rights of Article 326. Maternity relief, protection from domestic violence and property for work rights are also included. Special provisions are also included under Article 15 Clause 3 and 4, and the right to live with dignity and challenge discrimination for Article 32. You can also take in lot of articles, for example property. You can also include children, women and children, and also during various social, economic and political issues. So these are just few constitutional rights. There are even more constitutional rights. So make sure that you all revise. Now looking into the prelims practice question, match the following countries with corresponding features of their approach to women's political representation. So here they have taken into account of different countries: Rwanda, Chile, South Africa and India. India's, we have seen women's reservation bill being passed. Implementation awaits after the delimitation. So here option B is only correct. Now the next topic is Uniform Civil Code. So here why it is in the news, because our Prime Minister Narendra Modi in his first independence address of his third term, that is for the year of 2024, he had mentioned about the UCC. So here looking into the definition, They seek uniform civil laws for all citizens of India in issues such as marriage, divorce, inheritance and adoption, replacing religion-based personal laws. So they come under Article 44 of DPSP, where the state shall endeavour to secure a UCC across India, and they aim to promote secularism, gender equality and legal uniformity. And they are looking into the legal background, they are in the part 4 of DPSP, where they are non-justiciable in courts. And these are the key judgments which supported the UCC. So the Minerva case, they balance the DPSP and the fundamental rights. Now looking into their constitutional assembly views, the supporters were including D.R. Ambedkar, K.M. Munshi, who advocated for gender justice. And here the opponents of the UCC, they argued that they wanted to protect the religious custom. So thus the result was the UCC was placed in the DPSP and it is not part of the fundamental rights. So looking into key articles, Article 14, Article 25, 26 Clause B on religious freedom and Article 44 of UCC DPSP. Now I hope the article is clear. Let us see prelims practice question. Here arrange the following events related to Uniform Civil Code in chronological order. So first is the Goa's UCC, known as the Portuguese Civil Code. They existed since 1867 and they were applied to Goa post 1962 integration. So here next is the Minerva's Mills case. Next is the Shah Banu's case, where there was strong push for the UCC by judiciary. And next is the Jose Paulo case, where in 2019 the Supreme Court praises Goa for the implementation of UCC. So here the answer is option. Now the next topic is lateral entry. So here why it is on the news, because the center asked the UPSC, that is the Union Public Service Commission, to cancel the lateral entry advertisement, where they say they need to look into the process and need to be reviewed to add quotas. So what is the definition? So lateral entry means it is the recruitment or recruiting of private sector professionals, academicians or PSU, that is the public sector undertakings, into the middle senior government posts or positions, for example joint secretary and director, on contract basis for 3 to 5 years. So this aims to bring domain expertise from different fields, improve the governance by participation of different fields and people, and also fill the personal gaps. So here the mode of recruitment is through the UPSC and not through regular civil service exams conducted by the UPSC throughout the year. So check if UPSC is a constitutional body or not. And next, based on selection, and they are not permanent appointments. Now looking into their background, the lateral entry was recommended in the 2002 Constitutional Review Commission and second ARC, that is Administrative Reform Commission of 2005. So check how many ARCs have been conducted and check about different commissions, and also check how check the basics for how executive resolution are passed for the formation of ARC. And also in the Niti Aayog 3-year agenda and sectoral group of secretaries supported lateral entry, and the global models such as from USA, UK, Australia, they also follow institutionalized lateral entry. Now looking into the implementation of lateral entry in India, first was done in 2018, then in 2021 and 23 there were more recruitments, and now the looking into total appointment till date it is almost 63. Now I hope the article is clear. Let's see a prelims practice question. With the respect to concept of lateral entry in Indian government, which of the following statements are right? Lateral entry allows professionals from private sector to be appointed to senior government posts through selection process conducted by UPSC, and that is right. The primary rationale behind lateral entry is to bring in specialized knowledge, enhance governance and address staff shortages in specific sectors, that is also right. Now next statement, lateral entry into government post is backed by constitutional framework, no. Ensuring compliance with reservation policies for marginalized committees, no. The first round of lateral entry appointments in India took place in 2021 with total of 63 appointments. Here not 21, 2018. So only the correct answer is statement 1 and 2. Here the statement 3, they are not backed by article 309. So here 309 of Indian Constitution deals with recruitment and conditions of service of persons serving the union or a state. So the other constitutional provisions can be taken into account, article 320, fundamental rule of 110, and the DOPT guidelines is to frame rules for selection, tenure and evaluation of lateral appointments. Now moving to the next topic, Law Commission of India. So why it was in the news? The central government has set up their 23rd Law Commission for term of 3 years. Now look into how such notifications are formed. So here the type, they are non-statutory bodies and not created by Parliament. So how are they formed? Now they are constituted by the Union Ministry of Law and Justice through a gazette notification. Purpose is to recommend legal reforms, reviews outdated laws and drafts for new law. So here looking into their composition, in the 23rd Law Commission, it includes chairperson members. So here a chairperson should be a retired Supreme Court or High Court judge. The members should be 4 people of full time, including member secretary, and up to 5 part-time people. And next they also include legal affairs and legislative secretaries who are the ex officio. So here the tenure is 3 years and they are appointed by the Appointments Committee of Cabinet, where it is headed by the Prime Minister. Now with reference to the Law Commission of India, consider the following statements. The Law Commission is a constitutional body, no, established under article. So here the first half of the statement in itself is wrong. Now the recommendations of the Law Commission are binding on Parliament for enactment of law. No, they are advisory in nature. The third statement, the Law Commission can include serving judges for Supreme Court or High Court as its chairperson or members. That is right. The fourth statement, the Law Commission must be constituted for every 5 years. It is not constituted. So which of the statements given above are incorrect? So here the option is D, 1, 2 and 4. And also don't forget to check in their notable recommendations, for example from the 22nd Commission, in the 20th Commission and in the earlier contributions. And looking into the other key facts, these are the numbers of reports submitted, and as I told, they are not binding, government is not obligated. Now next topic is about the rule of law in India. So it is one of the most favorite topics for UPSC. So here let us see why it was in the news. The Supreme Court's recent ruling reaffirmed the primacy, that is the importance of the right to life and personal liberty under Article 21, and even in cases involving stringent laws like UAPA and PMLA. Now looking into the definition, the rule of law can be seen as the supremacy of law over all individuals and institutions, including the government. So here it rejects arbitrariness, it ensures fair and equal and accountability. So here the rule of law in Indian Constitution, it is not explicitly stated or included, it inherited in the articles 13, 14 and 21. So it forms part of the basic structure doctrine, that is through the Kesavananda Bharati case, and it was reinforced by a preamble through justice, liberty and equality, and part of the Article 14, equality before law and equal protection of laws. So only for such, these are the exceptions under Article 361, where immunity for President and Governor, and Article 72 and 161 for the discretionary powers such as the pardons. Now what are the principles where it reflected in the Indian Constitution for the rule of law? First is the supremacy of the law for the Article 13. Next is equality before law for Article 14, and due process of law for Article 21, where it was interpreted by the Supreme Court case in Menaka Gandhi case in 1978, where no one can be deprived of life or liberty except through fair and legal process. So the due process is one of the most important addition for the rule of law. And next is for judicial review on the Article 32 and 226. Here courts can strike down unconstitutional laws, ensuring that no authority is above the constitution. And looking into the independent judiciary, here the basic structure doctrine ensures court can uphold the rule of law against arbitrary and legislative executive action. So these are the questions which was asked on the rule of law. So here you can see which of the following are regarded as main features of rule of law: limitation of power, equality before law, people's responsibility to the government, no. Civil and liberty rights, so option D. So here in the essence, what does due process of law means? So here it is fair application of law. Next is rule of law index is released by which of the following? It is by World Justice Project. So here why? Because A.K. Dicey, being a British theorist, he was the one who introduced the rule of law. So US having one of the most important constitutional provisions is through the rule of law, and they provide rule of law index through the World Justice Project report. Now looking into the prelims practice question, consider the following statement regarding the rule of law in Indian context. The rule of law explicitly mentioned? No. Rule of law is considered part of basic structure doctrine as per judicial interpretation, and yes. So option B is the only right answer. The next topic is anti-defection law. So why it was in the news? The anti-defection law aimed to counter political instability from frequent defections, ensuring government stability and party loyalty. So what is anti-defection law? It was inserted by 52nd Constitutional Amendment Act of 1985, and it was added to the schedule of 10th, and it applies to both parliament and state legislatures. Now looking into the objective, to prevent defections driven by personal gain or office, to ensure government stability and party discipline. And the grounds for disqualification under anti-defection law: here a member voluntarily gives up on party membership. Here the votes are contrary to the party whip, that is the official instruction issued by a political party, without prior approval. An independent member joins a party after election, and nominated member joins a party after 6 months of nomination. Now looking into only the exception, no disqualification if at least 2/3 of party members agree to a merger with another party. So here the decision authority is to the speaker or chairman under article 101 and 191. It empowers the speaker or chairperson of the house to disqualify members who violate the anti-defection provisions. And looking into their time limit, no specific time limit prescribed in the law. And part of the judicial review, here the speaker decision is subject to judicial review when malified intent, that is when they are having a bad intent or a bad faith. And next is violation of constitutional provisions and principles of natural justice. So I hope the basics are clear. So brush up on the topics. Now looking into the prelims practice question, consider the following statements. The law allows disqualification of nominated members if they join any political party after 6 months from the date of nomination. Yes. The speaker decision on disqualification under 10th schedule is immune from judicial review. No. The 91st Constitutional Amendment removed the exemption provided for group defections by raising threshold to valid merger to 2/3. Yes. And the law provides for fixed time limit within which the speaker must decide defection cases. So which of these statements are right? Yes, obviously only 1 and 3 are right. See here, we can see why statement 2 is wrong. Here in Supreme Court, the Quixote Holohan in 1992 held that the speaker decision is subject to judicial review, and the statement 4 is incorrect because there is no fixed time frame or law for the speaker to decide the disqualification cases. Now looking into one of the most spoken topic, that is the Waqf Act. So why it is in the news? Due to various legal and administrative developments in the Waqf Act. So here the Waqf system involves dedication of properties for religious or charitable purposes. So looking into the constitution provisions, they come under Article 25, 26, 29 and 30, and Article 14, which guarantees equality in administration of the Waqf properties. Article 46 directs the state to use the Waqf properties for social welfare. Article 39 to ensure resources used. Article 300A protects the Waqf property rights from arbitrary dispositions. Waqf Act of 1995, it governs the administration of Waqf properties, ensuring their proper management. So now the news is there has been recent amendment been made in the year of 2025 on those Waqf Act. So here the application of Limitation Act of 1963 also applies to Waqf property claims. So these are the constitutional provisions. Make sure that you have basics on the issue also. So now looking into a prelims practice question, the term Waqf was recently seen in news. It refers to Option C, a legislative act concerning the management of Muslim charitable endowments. Now, another spoken topic for this year was about delimitation. So, why it was in the news? It has become a major national issue in 2025 due to upcoming end of the freeze of delimitation for the year of 2026 on the number of seats in the parliament as well as state assemblies. So, here delimitation is known as redrawing boundaries of electoral constituencies, aims for equal representation based on the population, ensures fair allocation of seats in parliament and assemblies. So here, looking into the key facts, delimitation commission was created. It was statutory and not constitutional, appointed by president, works with the Election Commission of India. The decisions are final and binding and cannot be challenged in the courts. So looking into the constitutional legal basis, they come under the Article 82, where Parliament enacts Delimitation Act for each census. Article 170, delimitation for state assemblies, and then there were amendments such as 84th Amendment, freeze seat increased till 2026, 87th Amendment of 2023, readjustment based on 2001 census, and Delimitation Act of 2022, which is latest governing law. And why it was in the news more? Because of the Jammu and Kashmir delimitation of 2022, where the seats were increased from 107 to 114, and the 2026 freeze, where it brought in demographic imbalance concerns, and also southern states fearing losing seats to the northern states. So, for example, all party meeting, formation of Joint Action Committee JSC were conducted in Tamil Nadu for the delimitation. And next is demand for delimitation based on 2001 census. So these are the basics for the delimitation, and do check on its references. Now moving to a prelims practice question with reference to delimitation commission, consider. So yes, it is the constituted under an act of parliament. So next news is about the Prisoners Act. So here, why it was in the news? Because in 2025 there were new prison reforms being brought up, and this is the link to go and check. Now, what is Prisons Act 1894? So during the colonial era, it was a law during the colonial era and over 130 years old, where its basic aim was to bring in custody and discipline of the prisoners. So here the act lacked provisions for reformation and rehabilitation for prisoners. So it had prisons historically for punishment and deterrence, and now it is seen as institutions for rehabilitation and transformation, and also to reintegrate the prisoners as law abiding citizens. Now looking into the constitutional context, they come under Article 14, 21, Article 39A, where they mandate free legal aid to ensure that justice relevant for under trial prisoners. And also why it was in the news recently also, because the section 479 of the BNSS, where the release of under trial prisoners who have already served a significant portion of their maximum sentence, so to reduce overcrowding in prison and expedite the justice process. So because of this also it was in the news. Now looking into the other important provisions in the Constitution of India, the responsibility of managing prisons come under as a say subject. But here the central government also plays a supportive role in updating the laws and ensuring efficient management. So make sure that you guys have a basics on prisons as well as on police, because there are a lot of questions related on these two topics. Next, the Model Prisoners Act 2023 was introduced to update and replace the outdated Prisons Act of 1894. The Bureau of Police Research and Development were integrated to bring in relevant provisions from the Prisoners Act 1900 and transfer of Prisoners Act 1950. So looking into a prelims practice question, which of the following is not a feature of Model Prisons Act? So here the option is B. There are no provisions such as for electronic tagging post release. Now coming to the last topic for today's video, that is about the Madrasa law. So here the Supreme Court verdicts on private property, UP's Madrasa law. The Allahabad High Court have struck down the Uttar Pradesh Madrasa Education Act of 2004, declaring unconstitutional. So here the court said running madrasa boards with public funds violates the principle of secularism. So here Madrasa are educational institutions that primarily offer Islamic religious education and also include subjects like math, science, languages depending on the curriculum as well as on the region. So here the Uttar Pradesh government created the Madrasa Educational Act as a state support for the madrasas, but now it was declared unconstitutional for violating principles of secularism and right education, as it was seen as state funded. So here parallel issues of madrasa were built on private and Waqf encroached lands and triggered legal and administrative action. Looking into the key observations, the state cannot fund religious education institutions directly under a secular constitution, and this was one of their case. The act violates the basic structure and promotes segregated education, which is contrary to Article 21A and the National Education Policy. So here one of the issue was also how they were linked with the private properties. Many madrasas were found unconstructed on constructed on private land without ownership, Waqf land and litigation, and encroaching public government land, inviting demolition notice. So it raised concerns regarding Article 300A, protecting from deprivation without authority of law. So here these are the law constitution provisions being included. So check on the basics for this, and for this question make sure you give a comment in the comment section. So looking into the prelims practice question, with reference to the constitutional and legal framework governing religious educational institutions in India, consider the following statement. The right of minorities to establish and administer education institutions is subject to restriction of Article 28. The Article 30 Clause 1 protects only institutions imparting secular education, not religious instruction. The state cannot fund any religious education institution under any circumstances. Article 21A read with RTE Act, which mandates uniform curriculum for all children aged 6 to 14, including minority run institutions. So put in the comment section on which is the right answer. Now thank you so much for watching this video. I hope you're at the end of the video till now. So a very all the best for all of the aspirants who are attempting this attempt and for your future endeavors. So don't forget to give a like, comment and share, and to further not to miss any other content, subscribe to our channel. Thank you and have a great day.